There was another witness in court today, a friend of Linda Kasabian's, Mrs. June Emmer. She testified that Mrs. Kasabian has taken acid and LSD many times, and that in her opinion, Linda Kasabian is a liar. It's all part of the defense plan to prove that Linda Kasabian's testimony is completely untrustworthy. Dick Shoemaker, ABC News in Los Angeles.
This evidence of the sexual activity, this group sexual activity, as an indication of Mr. Manson's total domination over that family. You recall her testimony in court today was that he was the one that was ordering everyone to make love, and no one touched anyone until Charlie said so. We are offering this as an illustration of the power and control that Mr. Manson had over that family. We are offering it as circumstantial evidence that on the 2 nights in question, it was he who ordered these 7 murders, that he continued to exercise control over the family.
Well, the ostensible purpose for the introduction into evidence of evidence concerning a sex orgy was to demonstrate and indicate Manson's control and his dominion, so to speak, over the members of the so-called family. Obviously, however, the prosecution deliberately selected a sexual situation in order to illustrate Manson's alleged dominance so that they might, in their continuing process of slandering his character, put his character on trial rather than any conspiracy or any homicides. I suggest that their selection of a sex orgy to illustrate some aspect of his control over the other people in the family is just specious.
Paul, I understand that you and perhaps some of the other defense attorneys are a little unhappy about certain Manson family members being excluded from the courtroom by method of subpoena.
That's correct. First, I don't believe there is such a thing as the Manson family, but a rather loose confederation of people who temporarily reside at what's known as the Spawn Ranch are the people I was referring to. And every time these people come to court as members of the public to witness the proceedings, the prosecution serves them with the subpoena and has them excluded from the courtroom. Now, if the prosecution legitimately intends to call these persons as witnesses, obviously we have no objection. But to say the least, these are hostile, reluctant witnesses for the prosecution. If anything, they could conceivably be defense witnesses, but certainly not prosecution witnesses. And it's our position that they deliberately subpoena these persons and exclude them from the courtroom so that they're not there while certain of their witnesses testify, namely Linda Kasabian.
You don't think they would try to influence her by looks, by signals, by standing in the courtroom and saying anything?
Well, I think the prosecution feels that the mere presence of some of Linda Kasabian's contemporaries and contemporaries of Manson and Van Houten and Krenwinkel would intimidate her. Mm-hmm. I suggest that if she's telling the truth, they don't have any problems.
Mm-hmm. Yesterday, you know, one of the family members, or one of the Confederate members, as you put it, did attempt to smuggle a note to Linda, and it seems to me that is a form of intimidation.
I'm not aware of that.
Yes, Sandra Good attempted to deliver a note to Linda on the 9th floor yesterday afternoon.
Well, I'm not aware of that. I might point out that Sandra Good is a friend and acquaintance of Linda Kasabian. I don't see anything improper in attempting to speak with her. I mean, I don't know the circumstances and the rules and regulations regarding the passage of notes in the Hall of Justice, but you know, on the face of it, I don't see anything improper.
Thanks, Bob. That's been my problem for years. Gary, yesterday one of the family members, Sandra Good, attempted to smuggle a note to your client, Linda Kasabian, which in my mind is a form of intimidation. Do you have anything to say on that?
I shouldn't say that she attempted to smuggle a note. She handed a note to Charles Melton, who was with me, and he gave it to Linda. We've never kept anything from Linda that they've sent in. I'm tired of it. I think it's time they let her do as she pleases. They've attempted for months now, even going so far as to sit down in front of my law office to intimidate her and me. I got a phone call a couple of weeks ago from a guy about 8:30. He says, if Linda Kasabian takes the witness stand, neither of you will ever leave the courtroom. And I said, at nighttime, I said, look, do me a favor. If you're going to threaten me, do it during office hours. I'm tired of it at night. This is just another example of this kind of damn foolishness. There's nothing we can do about it. It was upsetting to Linda. It was right before she went on the stand. I was followed all the way upstairs to where she was, and she tried to force her way in and screamed out, in addition to that, something to Linda which was incoherent. And we're just bloody tired of it, period.
Well, is there anything that the district attorney's office or the court should do about this or can do about it?
That's up to the district attorney. It's been many years since I was in that position. All we want to do is have her finish testifying and leave town.
Thank you, Gary.
Thank you very much.
Well, Vince, even before this trial, Mr. Kanarik's had quite a reputation for being an obstructionist. Do you think that's a pretty good description of the man's tactics in the courtroom?
I better not say anything directly on that, John. All I can say is this. You've observed him for 5 weeks. You saw his demeanor. And now the trial has really got underway, and I think you will agree with me that there has been a dramatic change between the Kanarik you saw for 5 weeks and the Kanarik you're seeing now. I think you'll all agree with me on that.
Can you speculate on his motives?
To speculate on the motives behind Mr. Kanarik's doing anything would be a rather unprofitable undertaking.
Is he laying groundwork for the appeal of his case?
Again, I don't know that. This might be his motive, but I think you'd have to ask him directly on that.
How much longer do you think Linda will actually be on the stand?
I expect that Linda will be under direct examination for at least 1 more day, perhaps 1.5 more days. Now, after direct examination, of course, there's cross-examination. Cross-examination might last a day or 2. After cross-examination, I anticipate that we'll have Linda on redirect for another morning or afternoon session. So Linda's going to be on that stand for a total of about a week. Let's face it, she is the proverbial star witness for the prosecution.
Vince, are you as far along as you expected to be with Kasabian, or are these objections delaying you?
They're delaying the proceedings somewhat because there's 4 or 5 objections to every single solitary question that I ask. So obviously this is impeding the progress of the trial. I don't think there's any question about that.
Vince, has Linda Kasabian received any threats or any communications from members, so-called members of the family, regarding her testimony?
I understand that she received a letter from Sandra Good yesterday. I have not received a copy of the letter.
Do you know what it said?
No, other than what the newspapers and the television reporters said. I have no...
take any action regarding this?
I have heard an indication that the Los Angeles Police Department might decide to take some action against Miss Good.
What does the sexual activity of a defendant on trial for murder have to do with the charges of murder against him?
It's not the sexual activity per se. Mr. Stovitz and I did not create the facts in it.
Familiar faces. It's like my family.
What's the dictionary definition of that?
I don't know. I heard it.
You have a book of irreverence?
One more second here.
It's now citing the dictionary.
Tell us about your suit, Paul.
Very nice. I like that.
That's a badge of courage, you know. The prosecution spent some time on Manson's alleged sexual aberrations this morning, much to the defense's objection. Why are you objecting? The other activities that Manson and the family pursued.
Well, I mean, we're dealing with a purported sex orgy. As Mr. Kinerick ably pointed out, there's no indication at all that this took place. This is Linda Kasabian saying that such an orgy took place. She doesn't recall the date. She doesn't recall the identities of the persons present. She doesn't know any of the aspects surrounding the orgy. She has a vague recollection of some orgy and Manson being present and giving some orders. I think it's the weakest form of evidence we've seen so far.
Mr. Bugliosi doesn't seem to object to the purported sex orgy, but rather the way such a sex orgy was carried out and controlled by Mr. Manson. Do you think the fact that it was a sex orgy should prevent the prosecution from pursuing the conduct of Mr. Manson in this situation?
No, it's just simply that its prejudice far outweighs any probative value it might have. If he wants to illustrate that Manson gave orders, he might ask Linda Kasabian, didn't Mr. Manson send you down to the store to get cigarettes or candy or groceries? Or he could simply ask her, he could simply ask Linda Kasabian, did Manson give orders? I mean, we don't have to go into people's sexual behavior and conduct. And apparently, Linda Kasabian was a willing participant in this purported sexual activity. It was clear testimony that no one had a gun to her head. I mean, I think we're dealing with her sexual aberrations as much as we're dealing with any of the other defendants' sexual aberrations.
There's been a lot of time at the bench again this morning, and I understand there was an effort made to go into chambers. How do you react to that?
Well, as much as possible, the defendant's position is that we want this trial conducted in open public session. Now, certainly there are aspects of the case, legal matters, that should be conducted outside the presence of the jury. Legal matters concerning offers of proof, legal matters concerning expected and proposed testimony, and objections concerning some aspects of the evidence should be held outside the presence of the jury. But we're trying to limit the portions that are conducted at the bench as much as possible.
Well, since Ms. Kasabian has taken the stand, do you think that enough of her testimony has, and the arguments therein has been public?
No. It's not been public. I would say in the last few days we've spent as much time outside the presence of the public as we have inside the presence of the public.
Aren't you running the risk of alienating the jury with so many objections each day?
Yes. Yes, you do run the risk of alienating a jury. A jury doesn't like to sit there and listen to attorneys make objections. Obviously, the jury must feel that the defendants are attempting to hide something from them. The attorneys are trying to hide something from them. And every attorney takes that fact into consideration in determining whether or not he should interpose an objection. But as an attorney, you're in a dilemma. You obviously can't sit back and let improper, erroneous evidence be introduced against your client. So you have to make a decision. You have to weigh the tactical harm it's going to do to you by objecting in front of the jury against the value of the testimony that's attempted to be introduced against you. Now, you saw the balance, most of the objections being made by Mr. Kinerick. Mr. Kinerick obviously feels in good conscience that he must object, notwithstanding the influence it might have on the jury.
You think his objections are always proper?
Well, I don't in any respect question Mr. Kinerick's motivation. Because it does hurt him in the eyes of the jury. I don't think he's doing it in order to obstruct or delay the trial in any fashion. I think he's doing it because he legitimately and conscientiously feels that he must object to improper evidence.
Can you say now that he is hurting his position in front of the jury at this point?
I think it's a matter of... I think it's a matter of common knowledge that juries do not like extensive objections, and you saw some extensive objections. On the other hand, you know, Kenneric's position is that the prosecution deliberately asks improper questions in order to solicit and elicit him.
Thank you very much, Mr. Chairman.
This is the end of that answer.
Wrap this about that.